Those are issues that I wish to bring out in this, and I hope also at the same time I want to bring competence in my nature of work by the hard work I had earlier mentioned. So therefore, my lady, I think that's what I could say for now.
Very
Yes.
well. Justice Murima will follow up with these questions.
Thank you, Honorable CJ, and Okile, once again, welcome.
Thank you.
If I heard you right,
Yes.
you said you're a member
Yes.
of the Business Rent Premises Tribunal,
Yes. Yes.
BPRT. You are still a serving member.
Yes, I'm still a serving member. Yes.
Okay. Now, where do appeals lie from the BPRT?
Thank you for that question, my lord. Appeals from the BPRT go to the ELC, the Environmental and Land Court. All appeals.
Okay.
Yes.
And
yes.
when you're dealing with business premises,
Yes.
of course, one of the issues will be upon termination of a tenancy, rents, deposits, and all these.
Yes.
If a party finds itself in such a situation as in claiming rent deposits and less than $1 million, should this party of necessity come to the BPRT, or can this party go before the small claims court and file for refund?
My lord, I don't know if I got your question correct. Is the issue with regard to the rent deposit of 1 million?
Rent deposit
Yes.
of less than 1 million
Or less than 1
shillings.
million.
Should the claim be lodged before the tribunal, or can a party go to the small claims?
Okay. Thank you for the question, my lord. I think if you understand the jurisdiction, or at least of the BPRT, which is encapsulated under Cap 301, of who are control tenant. Control tenant is, and I think it's clearly stated on the jurisdiction of cases that we can handle as BPRT. So I think just to try and answer your question, my lord, we really do not have an issue of pecuniary jurisdiction, so to speak. It's the issue is he a control tenant or not? So I think that has been the jurisprudence when cases come before me at BPRT. So I think in such a situation, I am at liberty to handle such a dispute of a rent deposit, depending, of course, on the prayer sought by the tenant in such a case.
Okay. Will the small claims court have jurisdiction as well?
What has happened? We have it's an issue which, just to try and answer your question, it's an issue that was brought out during one of our meetings, whereby somebody brought such a claim of a control tenancy before the BPRT, issue of a rent dispute before the small claims court, and a party raised appeal to that effect, and of course the matter was removed from the small claims adjudicator, gave a ruling to the effect that he had no jurisdiction to hear this case, and therefore advised the litigants that the matter be transferred to the BPRT. Yes.
But what's your position?
My position is, of course, is with regard to the Act. What does Cap 301 say on a control tenancy? So I think that's where it comes to pass. If the tenancy is not controlled, then a dispute will be brought before the small claims. Okay. I think that's trying to answer the question.
Okay, and lastly, have you heard about the Maputo protocol?
Yes, thank you, my lord, for that question. Yes, I have heard about the Maputo protocol. I think it's
what is it in full?
I think it was not Maputo. I think it is an African, if my recollection comes. I'm trying to recall what it was about. I think it was an African charter with regard to women's rights. That was held in Mozambique, Maputo, if my recollection comes right. if my memory serves me right.
It's a protocol to the African Charter on Human and People's Rights, on the rights of the women in Africa.
Yes.
Now, what is this protocol about?
When I last read about this protocol, it dealt with issues with regard to women rights, issues to do with FGM rights to marry, issues of marriage. The protocol deals with issues of marriage, issues of
basically on women's rights
as a whole.
Okay.
Yes, as a whole.
Is that protocol part of the Kenyan law?
Yes, I want to believe under Article 2, Sub-Article 2, it is part of it's part of the laws in Kenya, and I think it should be embraced in any dispute, especially with regards to family law. I want to believe such. My understanding of such international legislations are to bridge the gap in our, if there's any gaps in the law, the court is at liberty to use such protocols, so that to bridge the gap in issues with regard to any lacuna of the law or an issue of law that is being raised in a certain dispute.
Okay, you are right that the protocol is part of Kenyan law, and Article 2, Sub-Article 6 of the Constitution. Kenya ratified this protocol.
Thank you.
With reservations.
Great.
That was in 2010 with reservations. What could be the reservations to that protocol?
I think the issue of, to my mind, my lord, is the issue of domestication. Domestication. In terms of what I'm trying to say is that it's not all protocols suit every nation. In terms of not all laws may be applicable to all nations. Sometimes they need to be domesticated, or they may need to be cultured to suit the norms, of course, according to the Constitution. So maybe that is why I want to believe in the wisdom. There were some reservations.
Yes, which are these reservations? That's my question.
My lord, I may not know those reservations. Since
you can't recall?
Yes, I can't recall.
Sorry, okay, thank you so much, and I wish you the best.
Thank you, my lord.
Thank you so much.
Honorable Attorney General.
Good afternoon again.
Good afternoon.
You are conversant with Murwatetu 1 and Murwatetu 2?
Yes, my lord. Yes,
so
yes,
please,
Madam Commissioner.
Can you explain to us the ratio decidendi in Murwatetu 1 and Murwatetu 2?
All right. When it comes to ratio decidendi, I'm trying to recall I cannot actually recall, but I think I just know the precepts of those two cases, whereby, of course, there were issues that were raised with regard to the constitutionality of Section 204 of the CPC. So I will be a bit not able to answer that question in full, because maybe this was a matter that was held before many judges, and there were dissenting judgments sometimes in the judgment. So maybe I cannot be able to fully answer that question. But maybe you could maybe rephrase the question to an issue that is relating to.
I can't hear you properly.
Sorry, I'm saying, I'm sorry. I'm not able to fully answer that question in full, because maybe the ratio decidendi in those two cases, in my view, related to the issue of Section 204, and of course the legality of the sentence to death. So I think maybe.
But to your recollection,
yes,
did it place any limit on the High Court's authority to depart from mandatory minimum sentences under the Sexual Offences Act?
Yes, it did. It part of the, I think it's Murwatetu 2, where the Supreme Court made some directives to that effect, and say that Section 204, the case related to murder case under Section 204, and not to mandatory sentences under other the Sexual Offences Act and other legislations that had mandatory and minimum sentences. So I think it does not relate to sexual offences. Just to try and answer your question, Mr.
Thank you.
Madam.
And finally,
yes.
How should supposing that you become a high court judge,
Yes.
how should a high court judge ensure that courtroom exchanges remain respectful and focused on legal issues, especially where counsel represents the state and not personal interests?
Okay, just come again. Just come again, so I didn't get.
How should a high court judge ensure that courtroom exchanges remain respectful and focused on legal issues, especially where counsel represent the state and not personal interest? Maybe not even the state. How should they just generally, both counsel that appear before court?
All right. With regard to the first limb of your question, how they should remain respectful, I want to believe a judge should give some guidelines on how litigants operate before this court. Guidelines in terms of the tone of speech, even the language that they use. I think I can recall a situation where when I was handling a dispute before at BPRT, and I had to warn.
You are crawling now.
So, I'm not scrolling.
I'm saying you are crawling. You are
Crawling.
not walking. Please do walk so
All
that
right.
we can hear you.
All right. I'm sorry. I don't know. Is it the gadget? My voice. Okay. I don't know whether my voice is. I will raise. All right. Sorry for that error. I was trying to say that there are situations where you have to give guidelines on how litigants speak, especially advocates from both sides.
At what point do you give the guidelines?
You can give the guidelines, especially when you feel things are getting heated up. There are situations where you can notice that things get heated up. It's more becoming a shouting match in your courts, which I feel it is not right. And you warn litigants, this is not how we conduct ourselves. And from there you can actually warn the relevant, the specific advocate who is speaking in a manner that is, I can call it's uncouth and lack of decorum. So you just have to warn them that this is not how we do things in court. Basically, bring the court under control so that it doesn't. In case
you warn them,
yes,
but they continue.
All right. Of course, that you have to now put your foot down and say, look, we cannot carry out proceedings this way. Either cancels you, either you change, or in such situations, and I think I'll hold you in contempt, because any advocate knows that there are certain norms and of how to handle cases. They know they should handle themselves with decorum.
Have you come across such situations?
Yes, I did, and I had to stop a certain counsel because my court became a shouting match, where one litigant was saying this, another litigant, and as I said earlier, the place became so heated that I had to stop the proceedings. I said, no, this is not how we do proceedings. Counsel, you must stop. You must conduct yourself with decorum. This is a court of law, and of course I had to put my foot down. And at some point, I don't want to mention the circumstances because I think we are live on TV, live everywhere. But I just had to put my foot down and say this is not how we do carry out proceedings. Yes, and with a warning, of course. Okay, I think there's a second link of your question. All right. Okay.
Good enough.
Thank you, Honorable Chair.
Yes.
Honorable Kipkirui.
Yes.
In your introductory remarks, you did indicate that you did a lot of soul searching before you applied for this job.
Yes.
Why did you have to do a lot of soul searching?
Thank you for that question, my lady. So, soul searching is you count the cost. You count the cost of being a judge. I think I have interacted with many judicial officers in the 1 year stint I've been in the BPRT. And I, of course, before even I applied, I had to do my research and find out how do you conduct yourselves, whatever, how in terms of, I'm sorry for that. I had to ask questions on how you conduct in terms of things to do with how your work-related issues, conduct issues with regard to...
So was it an easy or difficult decision?
It was a difficult decision, but I say that this is something I can do based on first looking at the work they do and the fact that it's actually a very heavy workload for the judges that I've encountered.
All right, fair enough.
Yes. Thank you.
Now, I'm sure you've been listening or you've been following these interviews online.
Yes.
And in the morning, we were talking about offenses that the law, the kinds of marriages that the law recognizes. And it became clear that there are two forms of marriage. That is Islamic as well as customary law that are potentially polygamous. You're aware of that?
Yes, but I'm sorry, I did not listen to those proceedings. In the morning I was held up somewhere, but yes, but it's okay. But
do you agree that those two forms of marriages are potentially polygamous?
Yes, I agree, my lady.
All right.
Yes.
Now, let's look at section 171 of the Penal Code,
Right.
which provides, I'll read it out for you, that any person who having a husband or a wife living goes through a ceremony of marriage during the life of the husband or wife is guilty of a felony and is liable to imprisonment for 5 years. What would you say about this offense in the Penal Code vis-a-vis what we've talked about, the two forms of marriage?
Right. Thank you for that question, my lady Commissioner. My understanding of Section 171, I think it's the offense of bigamy, if I'm not wrong.
Yes, it's the offense of bigamy.
Yes. My take is with regard to bigamy. This is when somebody who has celebrated a marriage, especially in especially before. If it's a Christian, from a Christian perspective, can celebrate in a church or in the AG's office and obtain a marriage certificate. It goes through the rigors of getting a marriage certificate and make an oath, exchange vows and everything. And then going ahead to conduct another ceremony such as this with another lady, I think that's when this offense of bigamy applies, especially when one has a marriage certificate, and then goes again conducting another, celebrating another marriage with another lady.
The question that I asked you, question, of course, yes. I mean, from reading section 171, we know what the offense of bigamy entails.
Yes, my lady.
So my question to you was, given the fact that we now know that the marriages, that there are two forms of marriages that allow for polygamy, what would you say about the existence of this offense in section 171 of the Penal Code?
All right. If the existence of this offense vis-a-vis now under the Islamic law, which of course it accepts more than one wife, I think I'm not, the little I know is that of course they are allowed to have more than one wife. And also under customary law, depending on the community that you come from, they do allow marriage for more than one wife. I think the departure here, my lady, is the issue of this registration. I think that's where I can say that if no one can, under an Islamic marriage, can come and charge somebody with the offense of bigamy, because it may not be applicable, because this is not a marriage that was celebrated.
So do you think that this section maybe should be reworded to say that it only applies to marriages that are monogamous?
For me, I don't think so. Maybe this is something that is ripe for just to be struck off. I mean, just to be repealed. Repealing is the right word.
For this offense to be done away with completely.
Because it may not be applicable.
But you've told us that a Christian marriage.
In a Christian marriage.
So
Yes.
when we remove it, what would
Yes.
happen to a husband who is married in a civil marriage?
All right, in a civil marriage, I think maybe we could. Maybe you are right, my lady, when you in your earlier sentiments that maybe we could put a proviso to that. Let's say it applicable to marriage that are celebrated in a monogamous setting. Monogamous setting in terms of.
So how many wives can somebody who is married under customary law? How many wives? Maximum number of wives is he allowed?
My lord, my lady, that depends, of course, on each and every community.
Your community, the KU?
No, we don't have a limit to the number of wives, depending on whether, as long as you can take care of them. I think the issue is if you are at liberty to take care of some, you have the financial ability to take care of them.
What about under Islamic law?
To my recollection, I think it is 4 wives, but I stand corrected. I am not.
You are actually correct.
Right.
Now, under the law of evidence, we talk about a wife being, or let me rephrase it, a spouse, be it a husband or a wife, is a competent and compellable. We talk about a competent and compellable witness. Is a wife a competent and compellable witness in a trial where the husband is an accused person?
My lord, my lady, to my recollection,
you seem to be doing a lot of recollection.
Yes, I'm trying to remember. Sorry, I'm sorry for that, for using that cliche.
No, it's okay.
Right, I'm sorry for using that cliche. When I studied the Act, yes, she's a witness, especially if it is an offense that relates to a sexual offense that affected maybe if it's a child. If the
say that again,
I'm saying in an offense, in a criminal offense where for instance, if unfortunately the father defiled the child, the daughter, for instance, then the wife can be a witness against him.
So an offense under the Sexual Offences Act.
Yes, maybe also maybe my thinking is assault also. In case of issue of assault, the issue of mistreatment of children. If there is evidence that while the child was in the custody of his father, he mistreated her, or maybe beat her or injured her, then I think the wife can be a compellable witness in such a situation.
Any other?
My thinking. Of course, murder, and God forbid if the father killed the child, maybe the wife can be a witness. Yes.
I'm not so sure, but under what provisions are you referring to when you say that?
I'm bringing the situation where what I'm trying to bring out, my lady, is this is a situation when the relationship between the husband and wife has broken down, whereby they are no longer, can I call them quote unquote husband and wife, and a situation happens where, of course, a child is defiled, or a child is killed, or mistreatment, and something to that effect.
I've said that's
yes,
okay. Yes, under the Sexual Offences
yes,
Act,
yes,
she is a competent witness for the prosecution.
Yes, but
any other offense?
I think those are the ones I can recall. But
and in an offense for bigamy, who would be the witness?
All right. Ordinarily, an offense of bigamy, it is the complainant who ordinarily is always the
would be the complainant?
The wife now. The wife who has been left by the husband and celebrated a marriage with another woman. So she can testify against her and say
finally,
yes, thank you.
Is a wife or a husband, for that matter,
yes,
a competent witness for the defense?
My lady, no, in certain circumstances, no. It's because of the relationship that is between them.
Did you hear my question?
Sorry, okay. I'm sorry for jumping your question.
A competent witness for the defense, where the husband has been charged. So when you talk about a relationship that, because of the relationship, it should not be made to cause further strain. That's what you're trying to tell us.
And also, it is goes without not knowledge that, of course, the husband, because the husband and wife relationship leads to the fact that, of course, the husband will be biased, or the wife will be biased towards the husband, and of course, he will testify in his favor.
So they are not competent witnesses.
In my view, yes.
I think you need to check on the law of evidence as regards that
Right.
aspect,
Okay.
whether a wife can testify during the defense hearing of her husband. Thank you.
Great. Thank you, Walid. I will do that.
Thank you, CJ. Counsel, how are you again?
Fine, thank you.
I want you to now speak up.
I'm sorry. I don't know. It's is it the microphone?
No, just your voice.
Okay.
Just,
Maybe my voice is.
Yeah.
Yes.
Don't whisper.
Okay.
All right. Now, in the case of Tatu Kamau versus Attorney General, the High Court, in a 3-bench, ruled that a willing adult woman or willing adult women do not have the freedom of choice to consent to FGM. You've understood?
Yes. Okay.
Now, do you agree that that's the correct position in law? And please explain.
All right. If I heard your question correctly, is if willing adult women have freedom of choice
Yes.
in FGM.
Yes, to consent to FGM.
Personally, I'll disagree. Why? Because of course we know what FGM stands for, and FGM is of course it's a rite of passage that has been declared unlawful under our laws and under the Constitution. I think this is very clear. So when a adult woman willingly wants to undergo that rite of passage,
Yes.
then it is more that either she has been coerced,
Yes.
or she has been cajoled, or there are circumstances which has forced her to undergo the FGM, and which, in my view, is okay. This is my speculation. My speculation is maybe because they want to get married, and one of the traits, or at least one of the reasons, I don't know, whatever community these adult women come from, for you to get married, you must have undergone the FGM cut. So I think that would be my take.
Yeah, but it's an adult woman. Doesn't she have the right to choose?
She has a right, but she has to follow the law. Yeah, if the law says you're not supposed to undergo the right.
Which one? Which law?
Okay, there's it's under the penal code. I'm sorry, but I'll need to research the specific section of the law in the yes.
An FGM Act.
Yes,
Anti-FGM Act.
The FGM, yes.
All right. Now I know you are a deeply person of faith, man of faith.
Okay, that's a big word, but thank you for that compliment.
Yes.
Yes, thank you.
So, do you think that that would affect you in the way you judge others who come before you, particularly people who might not be of the same faith, or who absolutely do not prescribe to any faith? For instance, atheists.
Atheists, all right. Thank you for that question. Just trying and decipher what you're trying to bring out. My faith, of course, is something which, but just to bring a basis, everybody believes in something.
Yes.
Yes. Just to try and answer your question, even atheists believe in something.
Yes.
Yes. They believe.
Yes. The actual question is:
yes.
do you think your faith will
So,
will affect your judgment if you are to make it to judge? Or there are certain issues that would come to you because of their controversy that you would not want to engage because of your faith?
Right. I'll try and answer a question with how I started. This is when I started my interview. I said that this is a calling.
Yes, that is why I'm going back to that.
Yes. So when it's a calling, then these are the things that you have to look into. As a person who aspires to an office of a judge, my faith should not in any way hampered my perception in cases of people who do not belong to my faith.
Okay.
I have to, of course, as a judge, I have to fidelity to the law, fidelity to the constitution. These are things I must hold up to.
Okay, let me give you a case scenario, a real case scenario.
Yes.
So the members of the LGBTQ
Yes.
come to your court and they say that they have a right to form an NGO, and therefore through that they have the right to associate.
Correct.
And yet, you know what our constitution says in terms of family values under Article 45.
Yes.
Now, would you consider that this is a valid petition to grant a remedy in terms of giving them the right to associate by registering an NGO?
Right, let me try and answer your question. I think one of the cardinal values of being a judge, which is one of the calling, is impartiality.
Yes.
Yes. Yes, I will look into the merits of their petition. I'll not look into what really they stand for. What are the merits of their petition?
The merit is that they, as Kenyans,
yes,
who associate themselves as LGBTQ,
yes,
they want to register an NGO so that they're able to associate in that space.
All right. So I'll look into the application.
Yes.
All right. So their petition. I'll look at their petition and look at have they followed the due process. From there, I'll look into, of course, the relevant laws. I'll also maybe interrogate many things with regards to had they applied and they were denied. And I'll look into...
Yes, they actually, the reason why they're in court is that they applied to the AG or to the relevant authority to register them, and then their objects were considered as being either repugnant to our customs or not something that was appealing to the person who's supposed to register.
Then in such a situation, I will look at the reasons why.
The reason is there LGBTQ.
All right, I'll look at what I'm talking about. Sorry for taking back. I'm looking at the relevant officer.
Yes.
That denied them registration.
Yes.
I'll look at the reasons why.
The reason is that the one I've told you.
Yes, and
so
interrogate it. Yes.
So they're coming to your court,
seeking
for a certiorari to quash that decision and an amendment to compel that officer to register that NGO.
So in my view, I look at the case holistically.
Yes, that was the answer then.
Yes, holistically, looking at all the parameters.
Yes.
And looking at all the issues that have been raised, and then do a lot of soul searching, and then come up with a decision based on the law and the constitution.
So what will be your decision based on the law and the constitution?
Based on the law and constitution, and looking at all the parameters. So unfortunately, it's something I need to do some soul searching and make a decision. Not right now, but it's something I need to think about.
All right.
Okay, but if a situation such comes, I will look into the matter holistically.
Okay.
It's something which we don't, because these are still Kenyans at the end of the day. We are not supposed to discriminate against them. But still, they also have to follow the guidelines when it comes to the act, and also look at especially why did the relevant officer deny them? I've told you. Yes, and
the reason is because
are those valid? Are they constitutional? And then from there, I'll make a decision based on that.
You know, counsel, you must, as a judge, you must be decisive.
Yeah, it's true.
So you can't. You must make a decision one way or another.
Okay.
You can be wrong or right, but you must make a decision. So I just wanted to know what your thinking is around that issue.
Yes, as I said earlier, I need to look at it holistically and come up with a decision.
All right, thank you. Okay, thank you. Thank you, CJ.
Thank you, Honorable Chair. Good evening, Gad.
Good evening, Madam Commissioner.
You can take water if you need it.
I think I'm okay, but I'll take it at some point.
Okay, no worries.
I have gone through your sample writings. You have submitted 5 of them. Submissions in a Court of Appeal matter, Chief Magistrate matter, High Court Civil Appeals, and decisions at the business tribunal. The tribunal. I have taken note that all of them are unsigned and undated. Why would you submit to us documents that are unsigned and undated? How can we authenticate that you are the author? And how recent are they? And in addition to that, the tribunal decisions are signed by one, okay, not signed, down there your name appears. I thought in tribunals you sit as a bench.
Right. So let me start by apologizing for submitting unsigned copies. I think that was an oversight on my part when I was uploading the documents. Yes, we do sign judgments. Just to try and answer a question, the BPRT sits in, it is individual member, and sometimes we sit collegial, depending on the circumstances.
So this one's why?
Yes, this was by me as a member.
Okay.
There are circumstances where we sit collegial,
okay.
Especially when we are sitting in a circuit.
Okay.
We go for circuits.
Okay. That's noted. Okay. So despite of that, the writings show clear legal reasoning. You're precise when it comes to issue framing, and you're able to clearly apply law to facts. They are coherent, well-reasoned, and they have clear conclusions. So I must commend you, though I'm not so sure whether you are the author with that past question. So in 1917, Chief Justice Sir Robert Hamilton, in the famous case of Rex versus Amkeo, you remember that case? We studied it in criminal law class.
I'm trying to recall it.
Okay, yes, so let me just read out what he had to say with regards to the place of customary marriage, whether customary marriage was recognized or not. This is what he said. I know no word that correctly describes it. That means the customary marriage. Wife purchase is not altogether satisfactory, but it comes much nearer to the idea than that of marriage as generally understood amongst civilized people. Is this statement applicable in the current constitutional and statutory dispensation? Kindly explain your answer.
Right, I think it is, in my view, it is not. Mm-hmm. My explanation is, I think the Honorable, I think it was a judge who wrote this, may not have taken into effect the true meaning of customary marriages in Africa. I think he looked at it from a lens of, I think an English lens, where he looks at marriage as more like a contract, where of course, as you mentioned earlier, wives are bought, which is not the truth. I think he failed to understand the issue of payment of dowry, what it entails.
So what is the current situation on the issue of customary marriage in the country?
The last time I did my research on that, customary marriage, when I read the Marriage Act, when I was doing a talk on the Marriage Act, customary marriages need to be registered. I think that's something they need to work on. So far, I don't know whether the AG has worked on a formula of registering customary marriage.
So does the law recognize customary marriage?
Yes, it does. It does. Under the Marriage Act, it does.
And the practice of dowry payment and refund of dowry, yes, is it considered, or are the two considered to be repugnant to justice and morality? And explain your response.
I beg to disagree. I don't think it is repugnant to justice and morality.
Both or one of them?
The issue of payment of dowry is not repugnant. And also refunding of dowry, in my view, depending on the customary principles. I'm looking at situations where let me start with the first issue. Payment of dowry. I think this is something that it is done by most communities, whereby a marriage is actually sealed or recognized under the customary marriages. That under the customary law, that this marriage has taken place because dowry has been paid. Then of course most people go ahead to register the marriage under the what's it called, under the get a marriage certificate later.
Just kindly restrict yourself to the questions that
so,
I've asked.
for me, I don't think it's required. Refund, I think it should be done. That is my personal view.
Okay.
Yeah,
Are you aware
yes.
of what the courts have held, including a court outside the jurisdiction, outside Kenya?
No, I have not read, but I think maybe I should read more on that. Mm-hmm. Yeah, when I think I read, I may have said something in the papers about somebody who asked for a refund of dowry.
Okay.
Yes,
Thank
and
you.
I think it was allowed.
Thank you. Thank you and all the best. Thank you, Chair.
Thank you.
Thank you, Chair. I think we can now have a discussion in a different area.
Yes.
You've been examined extensively on the technical aspects of the law. So let's look at some practical aspects. Earlier, when you were engaging with the Honorable Chair, you mentioned that you want to join the bench so that you bring transformation.
Yes.
In judgeship or on the bench.
Yes.
But you did not expound. Transformation in what sense?
Okay. For me, the transformation I seek to bring is, in my view, something I've been thinking about is expeditious delivery of justice. Having practiced in the High Court for some time, I've discovered that it's quite a challenge when you fix a matter, even a certificate of urgency. You are given a very far off date, about even 2 or 3 months, and this is a matter that is basically that needs to be expedited. So if my application be allowed to join to be a judge, then I would have to find ways to transform the process of expeditious hearing of especially matters under certificate of urgency. There are some dire situations that require litigants be given with. I can just think of situations like cases involving children or a dispute involving a business contract, amongst other things. So I think there could be a way. My view is we could navigate a way to that cases can be heard expeditiously.
So why do you think it takes so long to give a date for hearing of a certificate? Of course,
when you listen to what the judge has said, and rightly so, their diary is actually full. They are humans. They can hear cases to a certain limit. And of course, there are so many cases that have been filed.
Oh, so it's the numbers.
Yes, it's the numbers. So I think when you listen to what they have to say, and rightly so. Yes, I think having joined the BPRT, I was sharing with some of my colleagues that I stopped complaining about late judgments or rulings, because I have understood. I'm in the ground. I understand what they really go through. Yes, amongst other things. So I think the issue is finding ways, navigating ways and strategies to deliver expeditious justice.
Okay, at the BPRT, do you file returns?
Because we do file returns. At least the clerk who assists me there files returns for me.
And you get your performance reports regularly?
Not regularly. Not regularly. I think.
But you do get them.
Yes, after some time, maybe after 4 months, when we have our seminars, I'm able to know how I'm faring on.
Okay, how are you faring on? Because I do not have your report.
All right.
I can't tell why it was not uploaded here, but how are you faring on in terms of your performance?
I think I'm faring on well, in my view. I don't think I have any pending rulings on judgments.
Maybe you have no pending rulings on judgments because you don't hear cases. So when you tell me you're faring well, I expect to hear certain parameters.
Yeah. In terms of course, Yes, what I'm trying to say, what I'm faring on well is I think I am delivering in my view, but as I said earlier, I don't like to blow my trumpet. I would like maybe the record to speak for itself.
That's the record I'm engaging you on.
Unfortunately,
what does it say about your performance?
The last I checked, that was a week ago, I think I had performed well. That's the last I checked.
In what area?
In the number of cases I handled, and amongst the number of cases that was allocated to me. Yes, so I think I performed well.
Okay.
Yes.
Now, in the last SOJA report,
Yes.
We were given certain data or information regarding
Yes.
performance of
Yes.
different court levels.
Yes.
What was the case clearance rate for the tribunals? I know you are all put together as one level.
My lord, I don't know. I may have to check. Those are things I have to verify. So I don't want to answer something I do not know of. Or I don't
What
have.
about the Court of Appeal? I'm not sorry, not the Court of Appeal, the High Court, because that's the court you aspire to join.
My lord, I have not checked.
You did not check?
Yeah, but I think it varies from station to station, in my view.
No. The report in the SOJA was giving the total case clearance rate at court levels.
Okay.
So the tribunal was treated as a separate level, and you're given your own score, and so
Correct.
was the Court of Appeal, the High Court, Supreme Court, and even the Magistrates Court.
Correct.
Okay, you've had me use those parameters because I was waiting to hear from your report how you are doing in the different parameters. So in respect to case clearance rate, that's one parameter we measure, and then we also measure backlog clearance rate. Could you tell me the difference between the two?
The difference between backlog and
The backlog clearance rate or backlog reduction rate and case clearance rate.
okay. So,
How we arrive at those scores.
my lord, sorry, Madam Commissioner, unfortunately, I am not privy to how it is done. Unfortunately, because maybe I have not undergone training
Okay.
to that effect. So I may not be able to answer that question effectively.
Okay.
Yes.
Thank you. I wish you well.
Thank you.
Thank you very much, Chair, and welcome again, Gad.
Thank you.
Could you name to us some of the Bangalore principles of judicial conduct and explain to us how you will apply them as a judge?
Right. So the Bangalore principles of judicial conduct, I think the few that I can recall. The first one, of course, is impartiality. I think if I were to aspire to the office of the judge, I really endeavor to be impartial. The second principle I can recall is the issue of I think integrity. Integrity, that's the second I could think of. I wish to work with I seek to work with a lot of integrity in my work. The third one I'm trying to recall, one of the Bangalore principles is the issue of propriety. Propriety, therefore meaning that I need to work under the basic tenets of a judge, act with propriety. The third one, I think those are the three I can recall for now.
And
but I believe there are more than that.
Okay,
Yes, I believe there are more.
you will check on them later.
Yes.
Could you also explain to us your understanding of judicial independence, oversight, and accountability?
Come again, judicial independence?
Yes.
And?
Oversight and accountability. And tell us how the Constitution has safeguarded judicial independence.
All right, I think judicial independence has been set out. I'm trying to recall. I think it's under. I think it's Article 159. I don't. Article 156. I stand corrected. Article 156 that deals with the independence of judiciary. That article basically gives the parameters of how the office of a judge is independent from other arms of government, in terms of budget and how it conducts itself. So I think that is clearly, and that all touches on the issue of, I believe you asked the issue of accountability, if I heard you correctly.
Mm-hmm.
Yeah, I think that ties in under Article 156, no, sorry, 159 of the Constitution. I think your last question was the issue of confidence, if I heard you correctly.
Judicial oversight.
Oversight, all right. All right.
Who oversights the judiciary?
Okay. The judiciary may not have an oversight as such. Judiciary in itself, I believe it oversights itself by various bodies within the judiciary. One of which is the JSC, which I am before you. That oversights certain even rulings and judgments or propriety of judicial officers and judges, corrects them when they have gone wrong, amongst other things.
And the public has no way of oversighting the judiciary?
Yes, the public has ways. I believe when that could be done through the legislature, through Parliament. I think when Parliament have raised issues against this arm of the government as a judiciary that they are not performing, I think the public can do that through even through the executive when the issues of financial propriety or issues of corruption the executive can take up. And of course,
how does the executive take up?
All right, you can report a crime or issue of corruption. A corrupt practice of a judicial officer or
to who in the executive?
Of course, to the anti-corruption, to police and everybody. I think that's within the executive, in my view.
Okay, thank you. I wish you all the best.
Thank you.
Thank you very much. I think, Council, we have come to the end of the interview. And before we release you, we always give the candidate an opportunity also to engage us. So the floor is yours.
All right. First and foremost, I really appreciate the fact that I have appeared before you. I think appearing before esteemed members such as yourselves, for me, it's something laudable, something which I look up to, something I'm so grateful for. Secondly, I thank you for even the fact that I was shortlisted. For me, that is a big plus, and I'm grateful that you have shortlisted me and even allowed me to appear before you to express myself. And thank you for even the way the interview has been conducted. I'm really, not only me, but even other candidates. I pray that God will give you wisdom to. As I said earlier, to give wisdom to be able to make the right decision and identify the best candidate for the 20 slots that you seek to. And I hope that I will be part of the 20 that you will be chosen.
Okay.
Thank you. Thank you so much.
Thank you very much. On behalf of the commissioners, we wish you all the best and also encourage you. You send your code to serve. Although you have only served for 1 year and a half at the tribunal?
Yes.
The rest you are practicing?
My lady, I am also in practice. At the same time, I'm also in the practice. So I'm actually juggling.
Practice?
Yes.
So where is the calling? Is it in practice or in the tribunal?
Right now, I think my calling is towards the judgeship.
Your calling is where?
What I'm aspiring to be a judge.
To be a judge?
Yes, that is where I think that's a calling.
So the calling is coming, it hasn't happened.
Yes,
until you become.
Yes, my lady. Yes, my lady.
Very well. We wish you all the best, and also wish to encourage you to continue serving the public in whichever position you are in. When we complete the exercise, we will get in touch with you.
Thank you.
Have a good evening.
Thank you.
You may carry your writing pad and your water.
All right. Thank you.